Hello, hi, good morning. My name is Mia with Asian Americans Advancing Justice. Thank you for logging on Commutation and 2045 webinar. We will start with hi again. We will start with introductions and logistics in terms of the webinar itself. And again, I am one of 7 panel members today who will be presenting. I'm so very honored to help present for this webinar, and I want to remind you that in terms of presentation and audience participation and interaction that your log on GoToWebinar, and actually this platform is set up where as the audience member, you will be on mute for the entire presentation. So we won't be able to have a one-on-one dialogue with you. However, at the end of each segment, we'll provide time to answer questions you may have regarding our presentation. And how you can do that is in your little rectangular screen, there is a little blue chat box. And in that chat box is where you can type your message or questions you have for us. And please make sure you click the box, send questions to staff. That way your questions will be logged. And because we have over 200 attendees, and with only 1 hour and 30 minutes of presentation time, we apologize now that we won't be able to answer all your questions. Sorry about that. We won't be able to answer all your questions at the end of each segment, but we will try our best to answer as many as possible, and we will follow up with an email with any questions we weren't able to get to. And also, before we proceed, we want to clarify that this webinar is focused.
Yeah. Okay. That just honestly, I don't know.
And we want to clarify that this webinar is focused on commutations and not pardons. And the difference between a commutation and pardon is that a commutation is another type of clemency granted by the governor that does not or reverse, but rather allows the governor to reduce or eliminate a conviction. And the majority of those that apply for commutations are incarcerated community members currently serving life without parole, or LWOP, or determined and lengthy sentences. And a pardon is a type of gubernatorial clemency for people who have served time and who have turned their lives around, in which they have demonstrated exemplary behavior. Also, a pardon stores rights such as the ability to obtain a professional license and also allows for immigrants to open their deportation cases. And those are the main differences between a pardon and a commutation. And if you're interested in learning more in depth what a pardon is and or want to know how to apply for a pardon, you can follow up with me through email, and I would be happy to send you pardon materials from April's How to Apply for a Pardon AB 2845 webinar. And again, today for this webinar, we will focus on commutations, sharing information with you on how to file a commutation application, who qualifies for a commutation, why applies for a commutation, and we're also excited to share with you that in this presentation, a few of our panel members will be sharing with you their own personal experiences with the commutation process. And in this presentation, we'll cover other forms of post-conviction release if commutation is not a desired alternative. And with that being said, we can't emphasize enough that the purpose of this webinar is also a way to help empower you to help guide others on how to present a compelling commutation application. And we know that there are also audience members who are from states outside of California, and we recognize that each state has its own commutation process. However, we will share general concepts that you can use that can apply for your state. And as for attorneys in the audience who registered for CLE credit, we will, after the presentation, send you a follow-up email regarding CLE credit for this webinar. And lastly, before we proceed, for those who are not able to commit in joining us for the entire presentation, please know that this webinar will be recorded in its entirety and will be available for viewing. And I will be happy to share the recorded webinar with you through email. And again, thank you. Now we will move to the next portion of our presentation, the agenda. And what you see in this slide is an overview of the agenda for our presentation. And as you see, it's divided into 6 segments. And the 6 segments are introducing the presenters, overview of the commutation process in California, how to present a compelling commutation application, personal stories from our panel members, Candace, Chavez, Kelly Savage, and Tobias Tubbs. 5, understanding AB 2845, Pardon and Commutation Reform Act. And 6, post-conviction relief, follow with, at the end, questions and answers. And a reminder again that after the end of each segment, that is when we'll make sure to have time to answer your questions from the question box. And any unanswered questions we will leave towards the end of the presentation and our follow-up with an email. And now I would like to introduce you to our presenters. First, I have, again, say besides myself, I'm honored to have 6 great panel members presenting with me. And although I would love to highlight each and every panel member, why they are so amazing and share the awesome work that they do, however, in the interest of time, with so much context that we have to cover, instead I'll just briefly introduce each panel member, but also know that you have an opportunity to read the full bios, which will be part of the commutation materials we will share with you through a follow-up email. And our first panel member I'd like to introduce and welcome is Angela Chan. Angela is the Policy Director and Senior Staff Attorney at Asian Americans Advancing Justice, Asian Law Caucus, and the Criminal Justice Reform Program. And our second panel member, please welcome Caitlin Henry. Caitlin is an attorney and co-founder of the Prisoner Advocacy Network, a law clinic that trains and pairs people to provide legal advocacy to activists in solitary confinement. A third panel member, please welcome Colby Lenz. Colby is an organizer with Survived and Punished and California Coalition for Women's Prisoners. And our fourth panel member, please welcome Kelly Savage. Kelly Savage is an organizer and also the Drop Life Without Parole coordinator for the California Coalition for Women's Prisoners, and she is a very dear and great friend of mine as well. And our next presenter, our 5th panel member, is Tobias Tubbs. Tobias is the co-founder and pre-entry reentry coordinator for Words Uncaged and West Avenue Crop Swap, an urban agriculture business. And our 6th panel member we have, please welcome Candace Chavez Wilson. Candace is an organizer and volunteer member with Families United to End LWOP with Fuel and Fair Chance Project. And lastly, myself, again, hi, my name is Nourn. I'm with Asian Americans Advancing Justice, Asian Law Caucus, and I am the 2018 Yuri Kochiyama Fellow, and I work closely with the Criminal Justice Reform and Immigration Rights Program. Okay, and our next is segment, we will do an overview of the commutation process. And thank you again to our panel members for taking their time to help present and provide you some very informative information. And the commutation process in California. So with this, in terms of this segment, we will cover what is a commutation, why a commutation, how many commutations have been granted, steps of the commutation process in California, who can apply for a commutation, the commutation process in California, if you have 2 or more felony convictions, what does that mean, and recent commutations campaigns in California. What is a commutation and why a commutation? So, as we know that between the 1980s and 2000s, there's the misguided tough-on crime policies that spurred the prison boom. And with that, as of December 2017, the mass incarceration rate in California went from 130,000 to 260 folks, and about 5,000 are sentenced to life without the possibility, and in which 27,431 are sentenced to life. So essentially, like people that are serving life without parole and life sentences, they spend decades in prison, and after exhausting all appeals, rely on clemency as their main form of relief. And pardons and commutations are kind of like key avenues for a governor of California to recognize the harm caused by the mass incarceration crisis and to underscore the value of redemption and rehabilitation. In California, individuals who are convicted of a crime and can show that they have rehabilitated may apply for gubernatorial commutation and pardon. Specifically, again, a commutation is a reduction of sentence that doesn't eliminate the sentence itself. Again, it's, for example, if a person have like 28 life without parole, the governor can commute a person to 20 years to life, giving a person a chance to go to the parole board and earn a parole date and initially be released from there. And again, like sometimes commutations are only the way possible for many people serving life without parole. And how many commutations have been granted since then? From 1991 to 2010, 3 governors have commuted very little. Schwarzenegger, Davis, and Wilson in total granted only 28 pardons and 14 commutations. Now the next couple of slides, we will, and recently Brown, he's a governor that actually commuted the most, which was great, and Kelly and Tobias were recently commuted under Brown as well, and they'll share with you their stories. And currently, Governor Newsom, since he's been in office for the past 6 months, he's only 0 commutations, however, 7 pardons. So we're hoping soon that he'll be continuing the process just like Brown. And I would, so the next bond slide is the commutation process in California. And I'll go ahead and hand it over to Colby to share with you the steps of the commutation process. Thank you, Colby. Colby?
Thank you, Nia. Hi, everyone. So the first slide that we have here is a graphic to help show the process in California for commutations. So the first step is that applicants have to notify the district attorney in their county of conviction at least 10 days before they submit an application to the governor's office. So you can see that on the left side of the graphic with the scales. And not that that means we think that things are balanced and fair, but here we are. And then the second step, so once you notify the district attorney, we also highly recommend that people send that notification certified mail, if at all possible, because in the penal code that's listed there on the graphic, it specifies that you should be able to prove that you did serve notice on the district attorney 10 days before. And then once you complete your commutation application, some people do that on their own or with support from peers inside prisons, and others do that with the help of advocates and attorneys. You send that directly to the governor's office in the middle left there. And then if you are applying with 1 felony conviction, you then, the governor's office can recommend you for investigation by the Board of Parole Hearings. So that on the bottom there in the black text, the investigation can go to the board, and if they make a recommendation, that goes back to the governor's office, and then the governor has power to make a decision about whether to grant somebody commutation or not. And if you do have 2 or more felony convictions in California, there's a special process. We'll go into that a little bit more, but basically you have to be reviewed both by the Board of Parole Hearings through a vote in an en banc or a bench hearing. It's an administrative hearing. And then the second thing is that you have to get a majority vote from the California Supreme Court, and then they send their recommendation, both of those bodies, back to the governor's office. And then the governor's office gets to decide whether to grant you a commutation or not. Next slide. So who can apply for a commutation? In California, it's anybody with a criminal conviction in the state of California who is currently serving a sentence in California. In other states, it is the governor who has this power for people in state prisons. And sometimes each state has a different process for that. So some are also using the parole board, some have other panels for clemency, which is the umbrella term for commutation and pardons. And then for federal convictions, it's the president of the US that has the authority to commute sentences. So we won't be touching on those other states or the federal commutation process today, but we wanted to give a little context for that and then head into the details for California. So next slide, please. So as indicated in the graphic before, everybody applying for commutation in California, if the governor recommends their application for review, then it's the Board of Parole Hearings currently in California who investigates commutation applications. So that investigation is basically triggered when the governor's office recommends. for that to happen. And again, on there, there's the same reminder that applicants must notify their DA in the county of conviction 10 days prior to sending their application to the governor's office. This is really important too, because it used to specify that under Governor Brown's application, and now it doesn't specify that on the new application. So we want to make sure that everybody knows that that is still a part of the penal code. And then again, just to review, if you've been convicted of 2 or more felonies, you have to be reviewed by the Board of Parole hearings. We can share more information about those administrative hearings in our commutation guide that CCWP created and just revised, because many of us have walked through with people in that situation what that process looks like and learned a lot in the last couple of years under Brown. So we have some insights from people who've been through the experience in that guide that we'll share at the end. And then the California Supreme Court must review and recommend the commutation, and there's no timeline for that. Exactly, it goes on to the docket of the Supreme Court, and then they choose when they review these clemency applications, and then they report back to the governor. And also as an appendix to that commutation guide, we have a administrative order from 2018 from the California Supreme Court that specifies that they're supposed to only be determining if the governor is abusing their power in terms of commutation recommendations or grants, and not doing another review process about the merits of the person's application. So that's an important distinction, at least on paper. Next slide, please. So here we have some images to give a little bit of a background. The California Coalition for Women Prisoners, which is a grassroots racial and gender justice organization that started inside the women's prisons in California in the 1990s. One of our current campaigns that was also inspired and directed by organizers inside the women's prison serving life without parole. We are calling Drop LWOP, and it's a campaign to end all forms of death sentencing, including and prioritizing life without parole, since that's often dropped off the radar in our movements. And we're making the argument based on insights and experience of people who've lived these sentences that we want to end all forms of death sentencing, including death by incarceration, which many people inside call a living death. And this next image, thank you, Nia, is a photo of a Drop LWOP rally and lobby day that we did in Sacramento last August. And it was a combination of people who've survived life without parole sentencing, including family members and advocates and organizers and attorneys, with Californians United for Responsible Budget, to start making this demand more public, that we want to drop life without parole. And so one of our campaign strategies is to promote commutations for people serving life without parole as one possible way to make sure that people have the opportunity for release and to contribute back to community. Next slide.
Thank you, Colby, for sharing CCWP's highlights on campaigns. The next is Survived and Punished, Free the Malls. It's California, which Colby, Kelly, and I are members of. It's a coalition also nationally that includes our affiliates S&P and New York. We're all volunteer members, which comprise of survivors, organizers, victim advocates, legal advocates, attorneys, policy experts, scholars, and currently, again, from incarcerated people. And S&P, we focus on work to support and free from life survivors of sexual assault. Here in California and New York, we have launched campaigns demanding the mass commutations of survivors. Many of them have life and life without parole sentences, and we have had quite a few successes in California, such as Kelly's commutation from LWOP, and again, support from Survived and Punished for my freedom from ICE detention. And S&P also supports CCWP's campaign to end life without parole sentencing in California. And with that, I'm going to, Candace is going to share about FEAL and its campaigns. Candace, thank you.
Hi, everyone. Thank you for having me attend the webinar. So I am a member of FEAL, Families United to End LWOP. We began in 2016 with a lot of LWOP inmates at Lancaster Prison who are trying to brainstorm and figure out a way to kind of unite our families. And then in 2017, we held our first meeting with 6 people. As our membership grew, we began to network and realize that we can't do this alone. So a lot of our members are spread throughout California, Northern Cal, Central Cal, Southern Cal. We're also members of CCWP, Felony Murder Elimination Project, All of Us or None, SV Debug, Initiate Justice, SE Justice Group Sisters, and we have started nonprofits as well. Connected Against All Odds is led by one of our organizers, that's her nonprofit. And then we work with advocacy groups and victims groups, Mothers with a Message. Maria Moore has aligned herself with that organization. So we're really trying to kind of network and bring everybody around and make this a community effort. Also, what's important to note is that in 2018, 3 of our organizing members, their loved ones received a commutation from Governor Brown. And 2 of them have gone to parole board and been granted, so that's something that we're really proud of. Next slide. And in 2018, we launched a change.org petition. We titled it Seeking Redemption, where we garnered almost 9,000 signatures, and then we presented the petition to Governor Brown's office at a rally that we had. We also have made books that we presented to Governor Brown, highlighting LWOP letters and requests for their commutation or thank you notes or their writing. We put together booklets from CIW, from Lancaster, there was one from Ironwood, and we were able to deliver that message to Governor Brown and his staff in November of last year. Next slide. And then earlier this year, on February 26, 2019, we arranged a meeting with Governor Newsom's team, specifically his 2 members of his administration who were put in place to kind of deal with the commutation process. So what was interesting to learn is that every governor has seemed to have their own process in place. We're fortunate to have Brown for 8 years, so we all kind of understood what maybe his triggers were, where his nuances laid, that he tended to kind of make these public announcements or grant pardons and commutations around historic holidays, primarily Easter and Christmas. And then what we were surprised to find is that Newsom is not really adhering to that. So with every new governor, I think it was surprising for possibly all of our organizations to learn that Newsom really started this with like nothing in place. So when we set up the meeting with the governor's office, it was really to push for transparency with the commutation process and to refer to AB 2845, which is requiring that there is a response and a tracking. We asked for direct answers to when Newsom would be announcing commutations and pardons, if he would continue to also look at those with life without the possibility of parole, specifically for this demographic, as they will not ever be afforded a parole board hearing date. And then we also provided strong documentation about felony murder laws, special circumstances, and most of us know Joanne Shear and Felony Murder Elimination Project, so she is somebody who I think we've all relied on to get a lot of information and statistics from through the study that she's done and the research that she's done for the last 10 years in advocating for her son. And what I do want to point out is of the 5,206 current LWOPs on information that we have from 2017, 3,221 were under the age of 25. Most of the offenses occurred at the age of 19, and 3,700 of them are first-time offenders, so they have no priors, and that's really important to note. A lot of times when we address juvenile sentencing and reform, we're leaving out that youthful offender age, and that's important. Next slide.
Thank you so much, Candace, for sharing about FEEL and the history and of the successes that FEEL has had and the importance of commutations. And with that, we are at the end of this segment, and we'll open up for our first round of questions. Again, in your chat box, questions to us. We'll spend 4 or 5 minutes of it and see if there's any questions. Okay. Okay, so far we do not see any questions. So with that, we'll go ahead and move to our second segment, how to present compelling commutations application. Okay. So with this segment, when you fill out a commutation, application, there are 5 main questions that you answer. First is the conviction summary, the description of the circumstances of the crime, description of why a person is seeking a commutation, 4, explanation why a person should be granted a commutation, and 5, if a person has paid any monies to anyone assisting with preparing the application. And I'll go ahead and hand over the slides to Colby. Thank you for sharing on the conviction summary. Colby, thank you.
Thanks, Nia. So you can see an image here of one of the pages of the application under Governor Newsom. And the first question is asking applicants to list the convictions for which they're requesting a commutation of sentence. You can see that there. And then, of course, there will be links to these applications directly if you don't have one already. And then the second question that you can see is, were you under 26 years of age at the time of the crime for which you were seeking a commutation? And this is an important new addition under Newsom, which we'll talk more about later. Next slide. So then the second and first substantive main question on the application now says, describe the circumstances of your crime/crimes. And the way that we've approached this through CCWP with our members inside is kind of breaking apart potential suggestions for how to approach the question based on how much responsibility a person takes for their conviction. So the answers in terms of what we're suggesting depends on whether an applicant takes full responsibility for the crime and conviction, whether an applicant takes partial responsibility, but was not the person who caused direct harm, or whether the person maintains their innocence. Next slide. So for somebody who takes full responsibility for the crime of conviction, we recommend, of course, that people acknowledge personal responsibility and take accountability for the harm caused. And we encourage people to describe their understanding of the harm caused in detail, including feelings and impacts on individuals and community and family, and remorse for actions. And then we also encourage people to include any context for the conviction. So even if people take full responsibility for harm caused, if there's important context about the conviction and the harm caused, we believe it's important to include that. And we did see under Governor Brown, and we do believe that under Governor Newsom, there will be consideration for that context. And we've given a suggestion to frame that in a way of trying to understand how a person got to the place of causing harm. And it's important in each of these sections in the whole application, but especially in this question, circumstances of the crime, to always keep in mind that if you are serving a sentence like life without parole or a death penalty sentence, that getting a commutation would allow you to go to the parole board. It's very important to consider that whatever you write in your application, it's important for that to be consistent with your truth and with what you will present at the parole board. And that's complicated because the parole board has certain standards and hasn't tended to be responsive or open to when people take partial responsibility or maintain their innocence, but we'll get into that a little bit more. Next slide. And the one thing that I missed there was also sharing context. If your prison record is not only positive, if there disciplinary action that you received or that your family member or client received, it's important, we think, to include context there if that context is relevant to the disciplinary action. So we'll go into that a little bit more too. But the second section is if an applicant takes partial responsibility but was not the person who caused direct harm. And this we've seen as a very big category of people in California and probably statewide because of our sentencing laws. As Candace mentioned, various different accomplice type of laws often have people in this situation where they didn't actually cause harm or violent harm, but they were there at the scene or they were somehow connected by prosecutors. So in these kinds of cases, various kinds of aiding and abetting sometimes in felony murder cases and conspiracy cases related to all sorts of things, we recommend that people take responsibility for the piece that they feel responsible and have taken accountability for, but also give the context, the bigger picture. And we've seen many applicants who were granted commutation do that in a way that still allowed them the ability to get a commutation. So it's a fine balance between taking personal responsibility and sharing the actual context, sometimes the violent context, especially for survivors of sexual and domestic violence. But it is important for the governor's office to hear, and the parole board as well, as complicated as that is. Next slide. So if an applicant maintains innocence, we recommend, in working with many attorneys who also represent clients who maintain their innocence, that if there's a way to find a balance between what people, again, can take personal responsibility for without claiming that they did something that they did not do, we recommend still presenting, for people who maintain their innocence, who've been incarcerated. Often people have done a lot of work, a lot of self-development work in that context. So, weighing on that, describing the kinds of work, the kinds of self-help groups, the kinds of work that you've done in yourself without taking responsibility for something that you maintain innocence about is important. And sometimes people are encouraged to talk about how they might have found themselves at a scene of a crime where a conviction came next, if they did not play an active role in causing harm. Next slide.
Thank you so much, Colby. This example is the circumstance of a crime that have been on an application itself. For example, this applicant wrote the date of the crime. He argued with his victim over a dice game, led to an argument. And essentially, the main key point is he used accountable language, showing accountability. In writing is what will help an application appeal to the governor, because without using effective keywords and demonstrating that the applicant is no longer the same person convicted of the crime, how else is the governor going to believe that the applicant has changed? Again, sharing honest feelings about what led up to the crime and details applicant's actions, shows taking responsibility. Also, at the end of the presentation, there will be resources section that will explain further details by guidelines and how to use accountable language. And why an applicant is seeking a commutation. So overall, a commutation is based on California Penal Code 4801, which states that commutation grants are for reasons such as good conduct, using unusual terms of sentence or any other cause, including evidence of intimate partner battering and its effects, which Colby had shared. And then with that, describe anything about the context, of your life that mitigates or lessen the gravity of the offense. For example, you were suffering from addiction, you were a youth offender at the time, and a victim of abuse. But don't forget, if a person chooses to take full responsibility of the crime, that it's best to first acknowledge personal responsibility and individual culpability, and how you understand the harm you caused, how you feel, and show remorse about your actions and choices. And why applicants should be granted a commutation. There are three main points to cover. Since your life convictions, this is when applicant describes personal internal change throughout the years of incarceration, what was the applicant accomplished throughout incarceration. The key points to cover are change and rehabilitation, undue burdens, factors against recidivism, or again, why a person wouldn't return to prison. And why applicants should be granted a commutation in terms of change and rehabilitation. Change and rehabilitation describe the process of which, how did you change and what programs or groups helped you, self-help groups that you did to work on for this process. And example, you did community work and insights, you volunteered self-help groups, taught classes, volunteered at the hospice, educational accomplishments was bad, substance abuse programs you were in, being able to explain that you have insight and then have achieved about your circumstances, behaviors, and patterns, all that, being able to describe that. And definitely highlight your positive prison record, what you're going to do, your vocations as well, educational progress, courses that you've taken, college degrees that you've earned, work record. And all of that is part of showing your change and rehabilitation. And Colby is going to present on the next slide why applicants should be granted a commutation on undue burden.
So one of the ways that we've worked with people inside on this too is to support people to describe any undue burdens they face while incarcerated. And I think under Governor Newsom's new application process, they've indicated an interest in seeing how a commutation would impact somebody's life. So that opens the door, I think, even potentially wider than under Governor Brown for people to describe harms that they're facing while incarcerated as another reason to support a commutation grant. So some of the examples that we give here are if a person is elderly, disabled, very sick, or faces particular forms of discrimination. So a couple additional examples I'll give is if somebody's a primary caretaker for children or for elderly people and they're being separated from being able to do that care and life-sustaining work. I would say if somebody is managing severe mental health issues inside prison, and we all know that the conditions only exacerbate those mental health issues, so describing that experience and the burdens that causes. And another example would be for gender nonconforming and transgender people in prison who are facing high levels of discrimination and violence, describing that experience. And I think the other thing that describing those real conditions of imprisonment can do is help balance sometimes prison records that don't look perfectly clean, in large part because of discrimination in some cases. So we encourage people to strike a balance of describing the conditions that do create more burdens while incarcerated for that individual. And at the same time, it's a delicate balance of not wanting to very overtly criticize the system, but I think there are ways to manage the language there to be able to tell the truth about what someone's experiencing in their claim and their request for commutation, while also describing the real experience. Next slide. And then, so for this one, then the other area that we encourage people to write about is factors against being sent back to prison if commuted, right? So we all know that especially long-termers have an extremely low rate of recidivism if they do get the chance at release, but this isn't generally the mainstream kind of knowledge, or there's not a ton of acceptance about that fact yet. So what we highly encourage people to do, and it's the governor's office is asking for it directly now, is to describe your release plans should you have the chance for release. And that people have done that by going into as much detail as possible about getting housing support, getting support group information and sharing that, having all sorts of plans if sobriety is an issue for you to get released and support, including that information. So again, we'll share the commutation guide that goes into much more detail about that. Certainly employment or education, medical care if you're suffering from illness. Next slide.
Thank you, Colby. This is an example of why you should be granted a commutation. The example and the highlights are that the applicant describes insight and remorse for the crime, who has been affected besides the victim, of course, the victim's family, the community. The applicant here states that having good moral character and have achieved accomplishments to back up applicant's claim, again, of good moral character. An applicant demonstrates to be a productive citizen who is willing to commit to obeying the laws and has sustained reentry programs and to partner work to help applicant transition in the community. And again, the examples are also part of the resource that we will follow up with you. So yes, it'll be available for you. And attachments to the application. So what I've experienced is that sometimes folks tend to like my file or my application is not thick enough, or it doesn't have enough. But again, every commutation is different, is unique of its own, and support. Some may have more support than others, but again, support letters are very important, and it can be submitted even afterwards, after you send in your application. And support letters can be from family, friends, clergy, or spiritual leaders, people inside, staff members inside. The people should be able to describe the concrete support that they want to offer you if you were released, and demonstrate their knowledge of your rehabilitation for yourself, and public support. And I think one of the key to highlight when it comes to campaigns that it is very helpful when you have community support. This can actually flag the governor, through online petitions, individual postcards, and that, that has worked with CCWP and Survived Unpunished and FUEL as well. And again, attach your maintenance plan, whether it be a relapse prevention plan, attach self-help highlights, work experience that you've had or accomplished in prison, your parole plans, 1 year, 3 year, reentry plans, job offers, letters of accountability to your victims, again, support letters from agencies outside that's willing to offer you that support. And then Colby will explain the application changes under new Governor Newsom. Thank you, Colby.
You're welcome. So we wanted to highlight some of the applications since we have just recently moved into a new governor's administration. And so right here we have direct quotes from the Governor Newsom's priorities in deciding whether to grant a commutation. So the first section is about public safety, interests of the community, and interests of justice. So of course, these are very broad terms, right? So we encourage applicants, family members, and attorneys to work with a person inside to support them to think about how they can contribute to community in a way that, of course, will increase public safety. And in the interest of justice is an area where I think in some ways they are indicating a recognition that so much that happens in the criminal legal system is actually highly unjust, right? And very much motivated by racism and classism and sexism, ableism, and so on, anti-immigrant sentiment. And so I think that opens the door for people to describe their experience in a way that is more comprehensive. And then the second section is the age and circumstances at the time that the person was convicted, the sentence imposed itself. So I think that's an indication that they're looking at extreme sentencing of all sorts, including through sentencing enhancement. And then the age of the applicant at the time that they're actually applying. And there we have some information to know that they are considering elderly people in particular. And then the next one is the applicant's self-development, right? So any kind of rehabilitative program, what they call treatment needs. We've already gone into some of that. And then the applicant's need for a commutation, which is its whole own point, which also indicates that they're looking at the undue burdens factors that increasing people's need for a commutation. And then the last is the applicant's plan for release from custody. So those are the parole plans that we talked about before, release plans. Next slide. And then in terms of new components of the commutation application process, we just want to highlight the ones that we see as most important at this point in terms of differences between Governor Brown's application and Governor Newsom's, since every governor can create their own process ultimately, except for what's made clear in the penal code around who investigates, so the parole board investigating, for example. So this, under Newsom, the application, as we mentioned, highlights whether a person was under 26 years at the time. And so we want to include anything that people want to say about their age, their young age, and what that meant for them. And then it asks applicants to talk about the impact on their life. So this keeps coming up, right? And then there are specific instructions on the governor's website asking people to indicate if they're suffering from terminal illness or severe and chronic disability, and to fill out the CDCR, the Corrections Department form. That's a medical authorization of release, so that they can gather more information about a person's illness and disability. And we understand that they're prioritizing people living under those conditions in prison. So we recommend that people, if you're not already considering an application with somebody who's incarcerated, who is ill or severely disabled, we recommend that people talk about that with people inside. And then the last thing is that Governor Newsom introduced a reapplication process, which we'll talk about on the next slide. So here's an image of the reapplication form. It's a one-page form that you'll get a link to at the end. And the next slide will describe some of this a bit. Thank you, Nia. So this reapplication process it allows people who applied for commutation under Governor Newsom, but only in the past 3 years, to submit that one-page form that we just saw to reopen their application so that they do not have to apply again. And for some people who did apply and did receive an interview from the parole board, they can indicate on that reapplication form that they did receive an interview, but not a commutation. And so that we don't know what that means exactly yet. We hope it means that those people who did not have a decision on their commutation might be prioritized to speed up some commutations early on in Newsom's administration. And so what this means is that the person's application is in the archive. So you have to submit this form if you want the governor's office to pull your file from the archives and then consider it. And they are considering applications that were not, people who were not commuted under Brown to be closed. So this allows them to reopen yours and consider it again if it was already under consideration or if it wasn't. And then people do not have to notify the DA if they're doing a reapplication form, since they already notified in the regular application form. And I think that's it. I just wanted to give a quick note that in the resources at the end, Emile DeWeaver, who was commuted from San Quentin, wrote a commutation curriculum. And some of the examples that we've used are from Emile's curriculum, which you'll have a link to. And I highly recommend it for many reasons, but including the work that Emile presents through Prison Renaissance about how to support people to describe their responsibility and any harm caused and take accountability for that in the context of an application. Thank you.
Thank you so much, Colby. So this slide, it has 5 suggestions for do's and don'ts for commutation applications. And in terms of definitely map out your timeline for when you want to obtain your supporting documents, essentially a few months leading up to when you do submit it. And folks can still send supporting documents after you submit your application. That's an as an attachment. And do review all your support letters for appropriate context. And do reach out to if you need help understanding Remorse and Insight. Community members Insight, there's Insight classes, restorative justice classes, that's very helpful. And for folks that are able to help others, if you're interested to know what humanizing language is, to avoid using criminalizing language, this is a link where you have access to explore more in depth what humanizing language is. And definitely do not minimize the causative factors that led to your crime. Take accountability, responsibility if you do take responsibility for your crime. And then with that, we will do a Q&A. Are there any questions for now? Okay, I have a question that said that we applied a year ago and just got a letter back from whoever viewed them. Okay. All right. Sorry, a little technical difficulties. 1 second, please. Okay. What should be included in a letter of accountability to victims? Is anybody willing to address this? Colby?
Hi, everyone. Sorry. I think probably everybody in the call might have a thing or two to say, and this could be a whole workshop, right? But letters to victims taking accountability, I think, can come in different forms. I think it takes a lot of, personal introspection to think about what you want to say, right? So I think it's hard to do kind of a template for that, which I'm sure the person asking already knows. But I think it's important for the letter to be as genuine, as heartfelt, and less. I know there are a lot of courses inside that have people write these letters, and I think sometimes they can read as a bit formulaic because of the structure that sometimes people present for those. So I think the more that it can be true to the person's experience and true to their heart and how they feel in terms of remorse, I think the more clear that comes across. In terms of some of the details that I think we might encourage people to do, I wonder if Kelly might be up for sharing any of that.
Yes, no problem. So I think, honestly, the most important is take it out of the I perspective this is what I've learned, this is how I've changed, this is what I'm doing now, because it's about the victim. So how have I harmed that person? What have I done to make amends to that, if I can, if that's a possibility? But most definitely looking at how were they harmed? What can, when they can't do anymore? Say a victim is a man and has teenage daughters. So they're not going to be at that wedding. They're not going to be at that graduation, whatever that may look like. Because if you're using the I perspective, this is what I've done to change, most victims aren't looking for that. And board is definitely not looking for that.
Thank you, Kelly. I have a question here. Who are the 2 dedicated staff members that Governor Newsom appoints to review these applications?
Sure. So the governor's staff, I believe they have more than 2 people. They have quite a few staff attorneys in the office. So the office is under Governor Newsom. There's the criminal justice department, or whatever they call it, division. There's the head of that. And then there's, then underneath that person, there's a head of clemency and parole. And then underneath that person, there are many staff members. And then there are other staff members in the office that I think have a hand in these decisions. But it would be the head of clemency and parole, is Eliza Hirsch right now, and then there are many staff attorneys and I think other support and administrative staff in that office. So it actually is, I think, quite a few people. And then of course they also rely on staff, investigative staff from the Board of Parole hearings, who do the actual interviews and write the reports and recommendations.
And I have another question. It says, in terms of reapplication process, is there a deadline to submit it?
As far as we know, no. I mean, no, it would say on the application. So the answer is no.
How often can a commutation be applied for an inmate?
Should I just keep answering these for speed for now?
Thank you,
unless I really don't know. There's no actual limit on how many times people can apply, but because the governor's office gets so many applications, I think it's probably best not to keep reapplying, and because you can always risk creating some level of irritation, right, at that office. But that being said, once you apply for commutation, you can continue to send in supporting materials. So that doesn't need to be a full new application, or a new reapplication form. That's just sending in more supportive materials, and you want to make sure that the applicant puts their full name and CDCR number on those, so that they get filed with their commutation application. So there aren't actually restrictions, but I think, if there are changed circumstances, that type of thing, I think you can just keep supplementing the application. I think we would probably all recommend more than sending in a brand new application. But in some cases, people make choices to send a brand new application for various reasons. And if that's really important to them, it doesn't seem like there's any very clear reason not to do that, but just with the consideration that the office is getting a lot of paperwork.
Thank you so much, Colby. Oh, yeah.
Nia, can I also add? Yeah. So I think it's really important that people know, one of the biggest questions I get is, I don't have a log number. And if I don't have that, it's not in his office, which is not true, but we know that it is their job to provide that. And we can't change the fact that they don't. But we can continue to, even emails. Some of the ladies have informed me that their family has gotten an email back to say, thank you for submitting X, it's in our file. So there's different ways to take those steps. And it's really, honestly, it's about what we choose to do to keep fighting for ourselves. Refiling, and okay, so I file in 17, I file in 18, and my verbiage is different. My accountability is less clear the second time. How is that going to look to them? Are they going to want to re-interview me? But if I submit additional documents, even though right now on the reapplication, he's asking that we don't submit, new information until they are clear and have distinguished who is applying and who isn't. If we take that time to just gather that information and have it ready, then it gives us that boosted ability to work on that relapse prevention. Most LWOPs aren't going to have a relapse prevention ready because we don't believe we're going home. So with that, if we take that opportunity to prepare that stuff, even though it feels better to know it's in this, have that opportunity to take time and wait. Wait doesn't feel good. I get it. I felt the same way, but please encourage your loved ones to wait. Just gather your information and make sure it's clear.
Great. Thank you so much, Kelly. Thank you for sharing that. Very insightful. It is 11:30 and there's many more questions that need to be answered, but we'll go ahead and move to our next segment. And this one, I'm really excited to present the presenters sharing their panel members sharing their commutation experience. And the first person I'd like to introduce is Candace. And I've actually had Candace slide up. So thank you so much, Candace. She will be sharing the commutation journey of her husband, Taiwan Wilson. Thank you.
Hi, thank you so much. Thanks for having my slide up. So I'm going to be really brief about my commutation journey, simply because it was, I think, unique. This is my husband in our family, and I would like to actually announce that he did have his parole board hearing on Thursday, July 11th. He was found suitable, and he was granted parole. Can we go to the next slide? So our journey began in 2017 with filing a commutation. I want to point out something that Kelly said, which I think is really important. The waiting is really painful, and the log number and the documentation that's involved with that. When I had reached out and along this journey, the only thing I had was the CDC number and his name. And in verifying that, even with this year, with people who I'm assisting, there's no log number. Don't panic, because they can find the person, they can find their paperwork with their CDC number and their name. And so I do know that the application does have, space for a log number. And I think there's always a lot of panic when the form's not filled out correctly. But those two pieces of information, the CDC number and the name, is all that's required, as far as they'll be able to find your loved one's information through archives. So in 2017, my husband had filed 2 commutation applications on his own, and we heard nothing. In 2018, I decided that we would file a third one. Our journey is a little bit different, where, as Kelly also pointed out, when you are sentenced to LWOP, I don't think having parole plans is really on a priority list, right? Because you're never thinking that you will get parole. So having a detailed parole plan is vitally important. I can tell you that this past 6 months, I felt like we were behind the 8 ball and really rushed to put a strong parole plan together. And had we been thinking parole plans, we would have had some of that information already established, right? So that's always really good, especially now with the new administration kind of making that a priority in the application, wanting to know what are your parole plans. I do also think, though, that anyone who has been granted a commutation as far as LWOP, their rehabilitation and their desire to be home and earn their freedom has really started early and like day one. They didn't just start last year thinking, I'm going to be a good LWOP or I'm going to be a good person and program now. And I know it's unfortunate that there's a lot of programming that's not available to people with those sentences. But what I can tell you from my experience with my husband is that after we filed the third one in 2018, and I attached 3 support letters and literally 7 pieces of paper, which was the support that our family could provide, a support from from religious aspect, like one job support, and then we had some Colby and a few other organizations wrote us support letters as well. Next slide, please. And then what happened next? So on October 18th, my husband and 2 other men were called into the program office and they were given an interview. On November 21st, the governor released his Thanksgiving press announcement. 32 LWOPs were commuted. And then on Sunday, December 23rd, my husband was one of 18 men at Lancaster State Prison who received a commutation. Of this group, 10 of those people were LWOPs, 5 of them were Asian Pacific Islanders. And here's what I can tell you again from my own experience, which is somewhat different because I do think that Newsom is trying to be more cohesive and kind of broad strokes, as Colby mentioned, is that for the last 7 years, he's been on a PPFR. He's been incarcerated for over 25 years. He really had begun programming since day one of his incarceration. He did have one 115 in 25 years. He was in educational programs. Again, we tried to be concise and provide sound support system as far as jobs and reentry and things of that nature, financial support. We did not have an attorney. He did not have a file full of chronos from wardens or administrative or laudatory things. We did not submit a binder. I did not do a change.org petition. And Kelly, I think, said it best. You have to be your best advocate. You absolutely do. So we have living proof here of 2 individuals on our webinar. And I'm going to pass it off to them.
Thank you so much, Candace. Kelly?
Hi. So for me, I think I was really blessed. I had a lot of support, both with CCWP, the California Coalition of Women Prisoners, and Survived and Punished. As you can see from the photo, a small portion of my Survived and Punished team is in that photo. I have had the opportunity to fight in court as well for several years, and when the opportunity to apply for commutation came about, my lawyers didn't want to do it at first. They wanted to continue the fight in court, and so I was very blessed to have people pushing at every area. I know that when we think about the idea of what commutation looks like and what the possibilities are, most of us didn't believe it was possible, which is why we have so many filing now. And you know, completely right, Candace, it is hard to stay in the belief system that something's going to change. Most laws we see yearly are about everybody else but us. There's always that little special clause, except, you know, LWOPs, except LWOPs, with everything. And so it's not about making our decisions around board for most individuals, because it's not a possibility. We do it because we want the change. And for me, I was lucky to have all the support when putting everything together, and then looking at what that was going to look like for everyone else in my community. So that's what I chose to do, is help others prepare, whether it was preparing for board or just preparing for release period. So that helped me to be able to have the same benefit. When I was commuted, I had just had an opportunity to breathe through it because I had extra time to prepare for board. I was prepared because I had court. So I had a different situation than most other people, because with the court process, we were filing for a while. And it allowed me to look at what that relapse prevention, what reentry plans would look like, and how I would make that occur. Now people are scrambling because we're stuck in a system where the governor expects certain things, but most programs aren't even going to allow or entertain a support letter to somebody who is an LWOP. You have to fight to say, I know I have the ability to get out, and this is approximately when I will get out. And can I have some type of documentation that I can go to your program? And that's really hard. You know, it's hard for somebody to stay hopeful in that moment. So that's where having support like California Coalition and loved ones and family members and Fuel and Felony Murder Act, those are all places that they need the most support, that are providing support to the incarcerated person, because most people don't understand that that hope is so minimal. And it's a matter of helping booster that support to whoever that individual is. Every single time somebody contacts an incarcerated person, that boosts them just a little bit more. And so I know that that's been really helpful when the individuals are writing me at the coalition, asking questions about, why are we even doing this? Why do people care? When they heard that we were doing a webinar specifically to educate loved ones, I have 3 different men who wrote back saying that they wanted their family to contact and that their family was hopeful now because people like us are working together to support their loved ones. And so it means a lot.
Kelly, thank you so much. Thank you for sharing. It is 11:40. Gosh, it's just getting by so quick. Thank you again, Kelly. And we'll move it to Tobias sharing his commutation process. And then after Tobias share, unfortunately, we won't have time for questions and answers. We'll proceed with understanding 2845 pardon and commutation. Tobias?
Yes, first of all, I'd like to thank everyone for giving me this opportunity. And like you said, for the dearth of time, I came in the system in 1991 under what are called the super predative narrative. And this narrative explained that not only were we not human, but, we was to be punished severely for many crimes, some real and some imagined. So what this did in my case was being a youthful offender, for one, first-time offender, never been in jail or arrested in my life. I was sentenced to death under the guise that I was incorrigible. I didn't even know what the word incorrigible meant, but it means cannot be cured or has no human good. And, that struck me very deeply as a young person that, man, I'm not even a young adult yet, but yet still there's no good in my life. So I challenged myself from day one. So when I hear, Kelly and Candace speaking on how we have to take our lives into our hands from day one, that's very important. So for the next 20 years of my life, I was in a place called Calipatria or Kilopatria. And it was some of the most brutal forms of incarceration that a human being can go through. But in those moments that I made the decision to allow my best self to come forth. I'm talking, this was about before any hope of a commutation, laudatory crown. We didn't even know what a laudatory crown was. We didn't have the kind of relationships with officers and staff to even ask or even submit for a laudatory crown. So when Kelly said we did it because we needed to change or wanted to change, I was doing it for myself. I wanted to prove my capacity as a human being to be human in the most inhumane kind of situation. So as we went from Tobias Tubbs to 876464, and then later on to a bar number, this goes to show how we are demonized. We take to various forms of incarceration. I'm talking about lockdowns and strikes and riots and people getting killed and hurt. So when you're disconnected in such a way, especially these prisons are in faraway places, it takes everything for our family who are often emotionally strained, socially strained, financially strained to come see us. We're often left to the brutality of the system. So to fast forward, in the midst of a lockdown situation, 2012, it was a race riot between the skinheads and the blacks on the yard. I was blessed and fortunate to be able to go to Lancaster, in which within 6 years, I was able to place myself in programs and circumstances and situations that allowed me to eventually speak before the governor's chief of staff, Nancy McFadden, may her soul be in peace, because she has passed since that time. So people ask me, how did that come about? For one, I chose to show up, and I really believe when we allow our best selves to show up in the worst of situations, that is something, if you want to call it God, universe, positive karma, whatever the case might be, it will usher you forth. I tell people all the time, let not commutation be your goal. Let every moment of your life make the decision, the choice to be your best self, and I believe that creates an enormous and precious energy that leads to commutation, the changes of laws and policies that allow people like ourselves who had no hope to come out. And if you're looking at my pictures, this is some of the work that I'm able to do. I don't even call it work because I love doing it. One is with Housing Worth. I was speaking if I was president, and that's one of my favorite pictures. That's me talking with the microphone with my little gray cane go on, and everybody's laughing. And that was a very precious moment because society has really no idea of who we are and where we've been for the last 30 years. They have no term or reference other than what we see in entertainment and television. So when you can come amongst them and they see that you are an extraordinary being full of love, light, and truth and hope, and you're always pointing back to the men and women who are still within those cages, still fighting just for a second chance. You know, we're not asking someone just to release us all out. You know, sit us at the table and see. And that's what I tell people all the time. You know, yes, I say board prep is life prep. If you've been preparing for your life, if you've been making the correct emotional, social, and spiritual, and often professional changes that you need to be in the worst of situations, when you sit before even the worst of so-called commissioners. Mine was Commissioner Montez. You know, she retired after my case, 6 hours. I wasn't afraid. I actually took the whole case when I wasn't even in the house during the case, but I took the whole case on because I know the power of influence. And I know if I didn't have the kind of influence on my co-defendants prior to that event, that dreadful event, then most likely it wouldn't came out to the ends that it did. So I came in and took the whole case, and she threatened me. And I told Ms. Montez, I'm already free. I was free before I came in. I was free within my heart. I was free within my mind. I was free within myself. Just my physical body at some point is going to catch up. So the next picture is with Words Uncaged, which is one of the organizations that stood in the gap with Dr. Roy and many other people who said that we have a light, LWOP prisoners have a light, or LWOP people or incarcerated people have a light, and we deserve to have that light seen. So we created an apparatus in the format through books and art and poems. And so that's the second picture. There's one thing I will say when we was talking about victims, and I was fortunate to be a part of various healing circles in which families and mothers was coming in, and the impact that crimes have on our communities. Yes, it's on the direct victims, but it's also on the attitude of law enforcement. You know, how many years can you go inside a crime scene and see those scenes and not become desensitized by the people who are committing such crimes? So, they're victims. I'm talking about animals. I'm talking about creation itself. So when we have that kind of insight that our actions, whether, intentional or unintentional, whether through ignorance or in poverty, we have to take accountable for that. So I thank you all for giving us this opportunity. We have to change the system, and the way that we do it is by coming together and galvanizing our resources, our networks, our talents, and let lived experience, people with lived experience speak. And so thank you all, and thank you.
Thank you so much, Tobias. Thank you for sharing really great, powerful narrative, and Kelly as well, and Candace. And we have about 10, 15 minutes left of the presentation, and we'll go ahead and I will pass it to Angela Chant. She will explain understanding AB 2845, Pardon and Commutation Reform Act. Thank you, Angela.
Thanks, Mia. So I'll explain AB 2845. This is a bill that we passed, we meaning the coalition that is supporting pardons and commutations. We passed last year. And it went into effect this year on January 1st, 2019. So it's now currently state law. It increases transparency and accessibility to the pardon and commutation process. Next slide, please. So I'll go over a couple of the key pieces of this legislation, which is now law. It requires the Board of Parole hearing to consider, it doesn't require that they consider, but it encourages them or requires them to consider that review of any urgent pardon and commutation applications, such as when an individual is seeking a pardon because they're facing a deportation, or an individual seeking a commutation because of a severe illness or because the other reasons that Colby gave, that the individual needs to take care of someone, or they are facing difficult conditions because they're gender nonconforming, etc. So if you have any of those urgent reasons, make sure you include it in your application to BPH so that they consider expediting the application. Also, it establishes a one-year timeline for BPH to review and issue recommendations. And this is specifically, unfortunately, only for pardons. For pardon applications supported by a certificate of rehabilitation. It does not establish a timeline for commutations. We tried to get that in, but unfortunately, the final version of the bill did not include that. But it's something that hopefully we'll pursue again in the future. AB 28405 also requires BPH to notify applicants when they receive a pardon or a commutation application. So this is relevant to people applying for commutations. When BPH receives the application from the governor's office, they're supposed to notify the applicant, whether it be in writing or via email, they've received it. They also need to notify applicants when they issue a recommendation to the governor's office. So those are 2 points of notification. Next slide, please. This next piece is about certificates of rehabilitation. This is for people who apply for a pardon, so I'll skip past that. And I'll go right to the piece about the governor's website. So it does make the pardon and commutations application available on the governor's website, and that currently there, if you check on Governor Newsom's website, they do have both an updated pardon and commutation application and a reapplication for those who submitted an application within the last 3 years, and it was not granted by Governor Brown, and they want Governor Newsom to consider the application. It does have that reapplication that Colby described earlier. It also clarifies that individuals are eligible for a commutation, a pardon, or a certificate of rehabilitation, regardless of their immigration status. There were, in some cases, district attorneys who questioned this, and we included in AB 28445 a clarification that immigration status does not disqualify individuals. Next slide, please. And this really only applies for people with a pardon, but if an individual has received a pardon or a certificate of rehabilitation, then the ban the box employment protections apply to that individual. And that's AB 2845, and we'll also send out a fact sheet that summarizes AB 2845. Next slide. These are the co-sponsors for AB 2845. Many of the people who are presenting on this call are part of these organizations. Next slide.
Thank you so much, Angela, for sharing on 2845 Pardons and Commutation Reform Act. If you have any questions in terms of 2845, please leave it in the question box. It will be logged, and we follow up with you with an email. And we're nearing the end of our presentation. And our last segment, Caitlin will be sharing on post-conviction relief, and I'll hand it over to Caitlin. Caitlin, thank you.
So there's 2 new laws that make relief available outside the commutation process, but in a similar manner as to commutation. So 1170 D1 was amended by legislation in June 2018, and legislation effective in January 2019 that allows CDCR, the county correctional administrators, which is basically the sheriffs, and DAs to write to the court to initiate a recall of sentence and request resentencing. The criteria are very similar to the criteria for a commutation. And so you can, if you're supporting somebody who's in CDCR, try to initiate the process to get CDCR to make the recommendation. They've made about 900 recommendations to the county court so far. Unfortunately, you cannot write the court yourself to initiate it yourself, but you could write CDCR, such as the counselor, the warden, any volunteer, and ask them for referral to the secretary, or write directly to the DAs or to the Sentence Review Project, which has certain criteria where they'll refer cases to the DAs. Next slide, please. So there are a few kinds of things that CDCR is considering in their, what they're calling a pilot program. Advocates will need to organize and mobilize pretty quickly when the notice and comment period opens. There's going to be proposed regulations to finalize this, but there's main criteria that CDCR has been using that they've taken from the legislation. And that's one criteria is exceptional behavior, and that's the most commutation-like. Another one is information or changes to legislation that may or may not have been retroactive. So they're processing some of the nickel priors from 1393 and some other legislative-based changes that allow discretion but aren't mandatory at the time of sentencing to now apply retroactively, where advocates weren't able to get something like a separate petition as they won in something like 1437. Here, this is a way to get legislation that wasn't retroactive or had a new petition mechanism to get back into the court, where people now being sentenced have an opportunity to have discretion. And then there's another sort of bucket, CDCR is calling them cohorts, where there's case law that passed after the time of sentencing or after the time that appeals were exhausted. And under those cases, people are serving unlawful sentences. So for the commitment offense, there might have been 3 enhancements, and they were all based on one of the elements of the commitment offense. And CDCR has set out some cases for that. Next slide, please. And there are a few things to consider that are similar to the commutations in the categories that are more discretionary and less about unlawful sentences, but are about unfair sentences or good behavior. And those are age, time served, physical condition, and things like that. So I'll leave more time for Q&A and wrap up there. I'll address this slide, which is the old process. This isn't the process that they're actually using right now, and advocates will have 45 days to come together for notice and comment rulemaking and to testify, and we're going to want to mobilize people to get better processes than the ones that are on the books right now, but CDCR isn't really using. So this is theoretically what they're supposed to be doing, that's in Title 15, but not actually what they're really doing.
Thank you so much, Caitlin, for sharing on PC 1170B1 and post-conviction relief. We have about a few minutes left before I start wrapping up. Let me see if there's any other questions regarding Caitlin or Angela's statement. Are there any stats on who has been granted resentencing since January?
Are there any what that have been granted?
Stats on who's been granted on resentencing since January.
Sorry, I can't understand the second word. Stats?
Are there any statistics on who has been granted on the resentencing since January?
Yes, there's statistics, and if you want them, go ahead and send me an email, and we can also send them out with the slides.
Thank you, Caitlin. So if you have any more questions for Caitlin or Angela or any of the panel members, please include it in your questions box right now. And while I'm wrapping it up, and again, thank you for our panel members for sharing their stories on their commutation process, their knowledge, expertise on the process itself. And the next slide I have is available resources that all the resources here, we will send it up with a follow-up email, as well as the actual presentation itself, which is part of the follow-up email. So please don't worry, all this information will be available for you to view to look more in-depth. Again, the 24/5 transition memo that we did recommending to Governor Newsom how to improve the pardon commutation process, the CCWP's prisoners commutation guideline that was very instrumental to part of our webinar that made it happen. Thanks to Colby and CCWP members, and of course, Amelcy Weaver's commutation curriculum and the commutation application. You can view it as well as the reapplication itself. And again, follow-up questions will be shortly following with you. And this is our presenters' contact information that will be available to you, their emails, and if you would like to personally direct emails to them, go ahead and do so. And any questions we did not get to answer, we'll follow up again with the email. And before we end, we want to remind you that if you are interested in viewing the recording of the webinar in its entirety, it'll be forwarded to you. And we thank you so much. A lot of context that we had to cover, questions that we're not able to answer with the 1.5 hours that we had. It's been great. And we thank everyone for taking your time, spending your Monday morning or afternoon with us. And we hope that you got a lot of valuable information out of this, and best of luck to you in helping others in applying for commutation. So thank you again to our great panel members, to everyone in the audience that stuck with us. And we look forward to hearing from you. And please look for a follow-up email and regarding the CLE credit for attorneys as well. Have a wonderful rest of the day, everyone, and please